Hello and welcome to today's deep dive. I am your host, and we are jumping right into a really fascinating topic today.
I'm your expert, and yeah, I am so excited for this one. It really changes how you look at the world.
It totally does. So to start, I want you to imagine a scenario. You are walking up to the entrance of this beautiful, quiet public park.
Sounds nice.
Right. And right at the gate, there's a big official-looking sign that reads, in bold letters, "No vehicles in the park."
Okay, pretty standard.
Exactly.
Hmm.
On the surface, that seems incredibly straightforward. Like, if you're driving your sedan, you obviously cannot just cruise right through the picnic area.
Yeah, that's definitely a violation.
But what if a local kid is riding a plastic tricycle? Is that tricycle banned?
Oh, that's a good point. Or, what about a veteran who wants to enter in a motorized wheelchair?
Right. Or, heaven forbid, someone has a heart attack near the duck pond, and a life-saving ambulance needs to rush in. Does the ambulance driver get a ticket for violating the rule?
Well, I'd hope not.
Me too. But suddenly, a simple 5-word rule just isn't so simple. Who actually gets to decide what the word vehicle means in that specific context?
And that question right there, that sits at the very foundation of how we govern ourselves.
Look at that.
For centuries, traditional legal philosophers have wrestled with exactly this kind of problem. But the thing is, they almost entirely did it from the comfort of their own armchairs.
Which is wild to think about.
It is. They would just, sit back, think deeply about the nature of language and authority, and essentially just guess what an ordinary person understands the law to mean.
Which brings us to our source material today. We are doing a deep dive into a comprehensive entry from the Stanford Encyclopedia of Philosophy. It explores this relatively new, highly disruptive field called experimental jurisprudence.
Or ex-juror, for short.
Yeah. Right, ex-juror.
Yeah.
And the mission of ex-juror is basically to stop guessing. These researchers finally got up out of the philosophical armchair, headed into the lab, and started using psychological experiments, fMRI brain scans, and behavioral economics to test how you and everyone else actually process the law.
And spoiler alert, the way our brains evaluate rules, fairness, and intent, it is often radically different from how the legal system assumes we process them.
Okay, let's unpack this, because before we can understand how the law applies to, like, a specific crime or a contract, we have to establish how the human brain interprets a rule in the first place.
Right. And that park sign scenario you mentioned, that actually originates from a pivotal 1958 thought experiment by the philosopher H.L.A. Hart.
Oh, wow.
Yeah, and for decades, it was purely a theoretical debate. But recently, empirical researchers decided to actually put it to the test on real lay people.
And they didn't just ask about the ambulance, right? They designed this whole experiment with 4 completely different scenarios to see exactly where the human brain draws the line.
Exactly. They wanted to see if we care more about the literal text of a rule or the underlying moral purpose of that rule.
So the first scenario they tested was the core case. Someone driving a standard car through the park at full speed. Unsurprisingly, everyone surveyed agreed that was a clear violation.
Yeah, no shock there.
But then they introduced the over-inclusive case. This is a scenario where an act violates the literal text of the sign, but clearly does not violate the purpose of the park.
Wait, the monument.
Yes, they asked people to imagine a functional truck being mounted on a pedestal as a war monument inside the park. Technically, it is a vehicle.
But it isn't endangering anyone or making noise.
Exactly. Then they tested the exact inverse, the under-inclusive case.
Which is where an act violates the purpose of the rule, keeping people safe. But it doesn't violate the text at all.
And the researchers used this super extreme example of a person walking through the park just swinging a live chainsaw in all directions.
It's a totally normal day at the park.
Right. I mean, clearly dangerous. But a chainsaw is definitely not a vehicle. And finally, they had an off-topic case where someone is just calmly walking. No text violated, no purpose violated.
So what's fascinating here is what happened when ordinary people were asked to judge these scenarios. The results totally upended traditional legal assumptions.
They really did. The public judged rule violations based on a simultaneous combination of both the text and the underlying purpose. They thought the truck monument and the chainsaw swinger were both rule violations.
But when practicing lawyers were given the exact same test, their brains processed the problem entirely differently.
They just looked at the text, right?
Exactly. The lawyers leaned heavily, almost exclusively, on just the literal text.
It's like, if you think about it in a domestic setting, it makes complete sense. Like, if a strict parent tells a kid, no screens before bed, the literal text is clear.
Right, no screens.
But if a kid is using a Kindle specifically to finish a history textbook for school, does the literal text matter more, or does the underlying purpose matter more?
The purpose being just making sure the kid's brain winds down for sleep.
Exactly. Most parents would instinctively allow the e-reader because they are enforcing the purpose, not the text. But I have to push back a little here. If ordinary people just mixed up text and purpose depending on the situation, doesn't that make the ordinary interpretation of the law dangerously subjective?
That's a very fair point. But X-juror isn't necessarily saying the law should be subjective. It's just highlighting the cognitive reality that our brains naturally, process moral purposes alongside literal text.
Oh, I see.
Yeah, humans are social animals. So when we read a rule, we are looking for the spirit of the law to maintain social order. It shows the legal concept of a rule has a dual character.
A dual character.
Right. There is the descriptive sense, what the words literally say, and the normative sense, what the rule is truly meant to achieve.
And researchers have even taken this cognitive approach to look at the very concept of a legal system itself.
Yes, the Society of Angels thought experiment.
Right, by Joseph Raz. The premise asks, do we fundamentally need coercion, like police forces, fines, prisons, for a legal system to exist?
Imagine a society of perfect angels who never have the desire to do anything malicious. But they still need basic rules to coordinate, like, deciding which side of the cloud to fly on.
Do they have a law?
Well, for a long time, legal theorists argued that without the threat of punishment, law doesn't exist. It's just advice.
But when researchers surveyed ordinary people, 59% agreed that a perfect, non-coercive society of angels still operates under a legal system.
Which proves that in the everyday psychology of the public, law isn't purely defined by the threat of violence. It's deeply defined by coordination and shared reality.
But of course, reality is that we do not live in a society of angels.
No, we definitely do not.
We live in a world where people intentionally break the rules. And this moves us from general jurisprudence into particular jurisprudence, specifically criminal law.
And this is where we look at how people judge the mind of the person breaking the rule.
Right. In criminal law, traditional doctrine relies on two distinct pillars. There's the actus reus, which is the guilty act itself.
The physical event in the real world.
Exactly. And then there's the mens rea, which is the guilty mind, the specific intention or knowledge the perpetrator had. Legally, you usually have to prove both.
But the problem X-juror exposes is that the human brain does not neatly separate the physical act from the mental state.
They get all tangled up.
Incredibly tangled. There's a brilliant experiment testing this by Fiery Cushman from 2008. It involves two hypothetical runners, Brown and Smith.
Oh, the poppy seed experiment.
Yes. So Brown desperately wants to win a championship. So he decides to poison his rival, Smith, by slipping poppy seeds into his food, genuinely believing Smith has a deadly allergy to them.
Okay, so the researchers split the participants into two groups. Group A is told that Smith actually isn't allergic at all. He eats the seeds, totally unharmed. Brown's assassination attempt failed. Then, Group B is told Smith isn't allergic either. But by total freak coincidence, Smith dies from something completely unrelated later that exact same night.
Like a lightning strike or something.
Exactly. Now, logically and legally, Brown's mental state, his mens rea, is absolutely identical in both scenarios. He attempted murder.
He should receive the exact same punishment in both cases.
Right. But human psychology doesn't work like a legal textbook. The participants consistently assigned more punishment to Brown in the scenario where Smith was completely unharmed.
Which is wild.
That feels entirely backward. Why on earth would the human brain punish someone less when a victim actually ends up dead?
It comes down to cognitive bandwidth. When the victim is unharmed, our brains can easily simulate the intended outcome, the murder, and we harshly punish the malicious intent.
Because there's no actual death distracting us.
Exactly. But when Smith dies from an unrelated cause, a totally independent physical event is introduced. That visceral tragedy basically crowds out our ability to fully process the hypothetical tragedy the perpetrator intended.
So the physical outcome blocks our assessment of the mental state.
Precisely. It shows human juries are fundamentally susceptible to outcome bias.
Here's where it gets really interesting, though. Researchers aren't just relying on surveys. You're using fMRI machines to look directly at the brain's wiring.
Yeah, the neuroscience here is incredible.
So, under the model penal code, there's a massive legal distinction between doing something knowingly and doing something recklessly.
Knowing means you're practically certain your action will cause a specific result. Reckless just means you are consciously disregarding a substantial risk.
Right. So neuroscientists put people inside brain scanners and asked them to evaluate different crimes. They discovered that a machine learning algorithm could look purely at the biological blood flow in the brain and distinguish whether they were evaluating a knowing state or a reckless state with 71% accuracy.
Meaning there is a distinct biological reality in our subconscious brains that recognizes these subtle legal categories.
But the conscious mind is a totally different story.
Completely different.
Another study, the Shen et al. Study, gave ordinary, jury-eligible people the exact official definitions of knowledge and recklessness. They had them read case studies, and the human juries completely failed.
They could not reliably tell the difference, even with the definitions right in front of them.
Which makes me wonder if a brain scanner can tell the difference between knowing and reckless, but a human jury can't. Are we basically saying that the model penal code is fundamentally broken for human juries? Like, should we just start scanning defendants' brains?
Well, ex-juror reveals this dangerous gap between legal doctrine and folk psychology. If a jury can't reliably apply the law's distinctions, it results in unequal treatment. Two defendants with the exact same mental state might get wildly different sentences just because a human jury couldn't parse the legal jargon.
That is deeply concerning.
It is. But, most of us will never need an fMRI scan to prove we aren't murderers.
Thankfully.
Right. But this cognitive gap shapes agreements you and I sign every single day, terms of service, medical forms, civil laws.
Contract law, for example, is entirely dependent on the concept of consent.
Right. What does it actually mean to legally agree to something?
There's this 2020 study by Rosanna Summers that tested this with a scenario about a patient named Marvin who needs elective ankle surgery. Marvin explicitly tells his doctor he will only agree to the surgery if his insurance covers it.
Otherwise, he absolutely refuses.
Right. So the doctor looks him in the eye and explicitly lies. He says, yes, insurance covers it, knowing Marvin will be hit with massive out-of-pocket costs. Based on that lie, Marvin says yes.
And when researchers asked lay people if Marvin had validly consented, a shocking 66% of people said yes.
Which is crazy. They believed he consented, even though he was completely deceived.
This runs entirely counter to canonical legal doctrine. In the eyes of the law, material deception invalidates consent. You cannot legally agree to something if you've been tricked into the premise of the agreement.
So why do 2/3 of people think a blatant lie still equals consent? Are we just wired to be easily scammed?
It comes down to a cognitive bias toward procedural compliance. Evolutionarily, explicit verbal markers like saying yes or signing a document were the ultimate proof of a transaction.
Ah, so we anchor on the explicit action.
Exactly. If the ritual of consent is performed, our brains check the box. We treat the words as binding, regardless of the deception.
But I have to push back hard here. If 66% of people think a doctor lying to your face still counts as valid consent, isn't the folk wisdom of the crowd actually just wrong? Why should the law care about a flawed popular opinion?
If we connect this to the bigger picture, that is precisely why experimental jurisprudence introduces the concept of conceptual engineering.
In social engineering.
Right. Just because ex-jur uncovers how lay people think doesn't mean the law should blindly adopt it. Sometimes revealing these quirks shows exactly where the law needs to protect us from our own flawed common sense.
Oh, so the law acts like a cognitive prosthetic.
Exactly. It shows lawmakers where they need to step in and engineer a stronger concept of consent.
We see a similar thing in tort law, which deals with civil wrongs and negligence. The entire bedrock of negligence is the concept of reasonableness.
Right. Did someone act like a reasonable person?
Researchers tested what ordinary people actually mean by reasonable. Is it a descriptive standard, meaning just what the average person does? Or is it a prescriptive standard, meaning what the ideal person does?
And Tobia's findings showed it is a distinct hybrid of both.
It's exactly like leaving a tip at a restaurant.
Oh, that's a great analogy.
Right. If you ask someone what a reasonable tip is, their answer is a mix of what they know everyone else is leaving the average and what they feel is morally right to support the server, the ideal.
Society needs that hybrid standard. It has to be attainable, but also slightly aspirational.
But all this reliance on layperson intuition brings up a massive structural critique of the entire ex-jur movement.
The expertise defense.
Yes. Traditional legal philosophers argue that legal concepts are highly technical, specialized tools. You need years of training to understand them. So polling lay people is essentially useless. They say we should only care about the intuitions of trained judges.
Right, the domain-specific critiques.
So what does this all mean? Because, I mean, it makes intuitive sense. You wouldn't poll people on the street to figure out how to perform open-heart surgery. You'd ask a surgeon. So why poll people on the street to define complex legal concepts?
This raises an important question. Law isn't just a science like surgery, it's a social practice. It only exists because we collectively agree it exists.
Right. It's meant to govern all of us.
Exactly. If the law's definitions of consent, cause, and intent drift entirely away from the ordinary person's understanding, the legal system risks losing its moral credibility.
And if it loses credibility, the public stops complying.
Precisely. But critics also have domain general critiques. Since Exture uses the same survey methods as psychology, it faces the same hurdles, like the replication crisis.
Although Exture actually has a much better replication rate, around 70%.
Which is quite strong. But there are still the limits of using abstract survey vignettes. A 2-paragraph story about ankle surgery strips away the messy context of real life.
And there's the weird problem.
Yes, heavily relying on populations that are Western, educated, industrialized, rich, and democratic.
If researchers only poll American college students, they might assume a certain view of autonomy is universal human nature when it's actually just cultural conditioning.
Though researchers are increasingly conducting cross-cultural studies to address that exact blind spot.
Well, we have traveled from abstract thought experiments about park science down into fMRI machines and the cognitive traps of everyday contracts. We've discovered our shared legal reality is surprisingly complex, sometimes contradictory, and uniquely human.
It's a living reflection of human cognition.
But there's one final, somewhat haunting thought to mull over. Our source material notes that researchers are increasingly using corpus linguistics and machine learning.
Oh, right, using large language models.
Exactly. AI trained on the entire internet to mathematically determine the ordinary meaning of legal texts. So as AI gets exponentially more advanced, what happens next?
That's a big question.
Will the future ordinary person the courts rely on no longer be a human jury at all, but an AI algorithm mathematically predicting what you think? Is that the ultimate triumph of experimental jurisprudence or the end of human judgment in the law? Something to think about the next time you see a sign in a park.